Hello friends, Namaskaram. Today I am going to discuss an important topic concerning acquittal in check bounce case. As we know that it is not very easier to have acquittal in check bounce case. The prime reason is that the concerned complainant is having the multiple evidences in his favor. And apart from that, there is a presumption of section 118 and section 139 of NI Act against you. So if you want to get success in a false check bounce case, you must remember that we have to change our pattern to work out. And one of the most important pattern of workout is the proper theory. And theory concerning the proper acquittal is the theory of probable defense. As we know that in a check bounce case, it is not required for us to sustain our defense beyond reasonable doubt. Apart from that, we are required to raise our defense by the virtue of theory of probability. That is called preponderance of the probability. And in cut short, in nutshell, we could say that it is basically indicating towards the probable defense. Probable defense is basically nothing but a way of defense in which the accused is required to raise a clause on the existence of the concerned complaint or the legal enforceable debt, and apart from that, he is required to create those circumstances by the way of sustaining evidences so that the court may assume that the existence of debt is highly improbable. So if the concerned accused is ready and willing to work out on that strategy, then he could be succeeded, otherwise he could not be. Friends, there are multiple ways in which we could raise a probable defense, and one of the way is to show the non-compliance of the statutory provisions. And concerning the same, I am going to discuss the important judgment of Honorable Supreme Court in which the said point has been recognized as one of the most important dominant way to be succeeded in a false check bounce case. The judgment name is Bijay versus Mani Paresh. Judgment is pronounced on 20th of December 2024. It is pronounced by Honorable Supreme Court of India. The petition number is 5556/2024. In the case at hand, the concerned complainant had prosecuted the accused under section 138 of NI Act. Ultimately, the accused had been acquitted by Honorable High Court. The said judgment had been challenged by the concerned complainant before Honorable Supreme Court with the specific grievances, which are that I am having the specific case, there is a transaction, and despite of that, there is a statutory presumption against the accused. But learned High Court had not considered all these aspects, and that's why the judgment of acquittal is totally perverse. It is liable to be set aside and quashed. And he submitted that the concerned accused deserves to be convicted as per section 138 of NI Act. In the present case at hand, the concerned complainant is having a very simple case. His case is that the concerned accused is having the friendly relationship with him, and he was in need of money, and that's why on account of love and affection and the relationship maintained, a loan of rupees 8,45,000 had been given. Out of that amount, 7 lakh had been given in the concerned accounts and 1,45,000 had been given in cash. To pay the same, the concerned accused had issued the check with a promise that when the said check will be presented in the bank, it will be encashed. To get the money back, the check was presented. Ultimately, it was bounced, means dishonored, with the reason of insufficiency of fund. After that, the concerned complainant had communicated with the accused to take the refund of his money, but he failed to pay heed on the same. Ultimately, statutory notice had been issued. When it had been served, even though the concerned accused totally failed to pay off the amount, and apart from that, he has not served any reply, and that's why he is guilty. And the concerned complainant had submitted that in that scenario, he is left with no option except to file a complaint as per section 138 of NI Act. And finally, the complaint had been submitted. In the said complaint, the concerned accused had been summoned, and when he had appeared, he had raised two probable defense. He submitted that it is admitted that there is a transaction, but it is between the individual. The present check is by the company. A concerned complainant has to show the existence of any transaction between him and the concerned company. There is no transaction on the record, and by the virtue of which it could be assumed that the concerned check had been misused. He submitted that on account of certain mortgage, the check had been given, but it is by the way of security and ultimately it had been misused. He submitted that there is a case of non-compliance because the check is by a company. He is a mere signatory on behalf of company, and that's why to prosecute him, it is sine qua non to prosecute the company first, and only after that the prosecution of individual is possible. He relied on section 141 of NI Act. So looking to the circumstances, the court found that the concerned complainant totally failed to array the concerned company as a party, even though he is having the case that there is no transaction of him with the company and he had given the money to the concerned accused in the individual capacity and check had been given by him, although he played trickist. But despite of that, the concerned complainant was bound to have the proper legal compliances, and if there is no legal compliances in that scenario, he could not be succeeded. Ultimately, all such circumstances had been considered by Honorable Supreme Court. Honorable Supreme Court submitted that in the present case at hand, although the concerned accused had been convicted by the court below, but ultimately he had been acquitted by the Honorable High Court on the ground of non-compliance of section 141 of NI Act. The court specified that the offence is totally technical. So when we are going to contest a technical case, in that scenario, it is duty of the concerned complainant to have the complete compliances of the statutory requirement. If he failed to do so, in that scenario, he could not be succeeded. And among them, section 141 of NI Act is imperative. It says that when a check is issued on behalf of company and company is not added as a party, in that scenario, the concerned accused in the individual capacity could not be prosecuted and convicted. So we are having the multiple instances wherein a check is issued by a company, but the company is not added as a party. But remember that the company must be a company which is registered as per the protocol of Company Act. It must not be a proprietary concern. It is something different. Okay now. So if the said compliances are not done, in that scenario, we could claim the acquittal. So we could say that such type of defenses are quite important. So it is my humble request to all of you to have a proper company. The benefit is that whenever there is a transaction between you and another person, and ultimately check is given by you on behalf of company, and due to certain reasons, if the concerned company is not added as a party, or if no notice had been given to the concerned company, and if there is no compliance of section 141 of NI Act, and apart from that, there is no passing of consideration or transaction had been shown by the concerned complainant, in that scenario, on ground of non-compliances, on ground of non-existence of certain material fact, we could have a proper probable defense on record and could easily claim the benefit of acquittal. So if you want to win, you may, but remember, to win a case, you are required to have a proper strategy, and probable defense is the dominant part of your strategy. So whenever you are having a notice of check bounce case, do not take it lightly. Make a proper reply, but while doing the reply, you are required and supposed to make a proper probable defense. If you totally fail to do so, in that scenario, you could not be succeeded. So all these points that are formulated by Honorable Supreme Court are not for a mere concern, mere perusal. We must learn from them because these are theoretical perspectives, and we have to apply the same in the practical way in our case so that we could be succeeded in a false check bounce case. So I think that I'm totally able to convey you the benefit of having a proper probable defense, benefit of section 141 of NI Act, and the impact of non-compliance. So if such circumstances are in existence in your case, please follow the said judgment, and inter alia you may rely on the same to have the proper acquittal from the court of law in a check bounce case. So see you in the next video. Till then, Jai Hind, Jai Bharat.